Hello, and welcome to Ipsa Dixit, the podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Andrew Carter, Clinical Professor of Law at the Arizona State University Sandra Day O'Connor College of Law. We will discuss his article, The Case for Plagiarism, which is published in the UC Irvine Law Review. So welcome to the show, Andrew.
Great to be here, Brian. Look forward to talking to you.
Yeah, me too. So as I was saying to you earlier, when I saw this paper come through my SSRN feed, I downloaded and read it absolutely immediately because, as you know, plagiarism is one of my favorite subjects. And I really enjoyed this paper, which I thought was exceptionally well written and 100% correct in my personal opinion. But I wonder if we could start by situating listeners a little bit into the problem that you're engaging in. So you've got a really provocative title, right? The Case for Plagiarism. What kind of plagiarism are you talking about, and how did you get interested in this subject?
Well, I should, if I describe the origin of the project, I think that'll cover it. So I teach legal writing here at ASU, and one of the tensions that we have when we teach legal writing is obviously we have a very strict academic rule against plagiarism, but at the same time, in practice, there are very modest forms of plagiarism that are widely tolerated. And so I wanted to sort of provide a guide for my students, that I fashioned sort of as an advocate's guide to plagiarism. And the notion was a little bit of plagiarism here and there, maybe when you're reviewing the analytical rules under Miranda, for instance. No one's going to bat an eye if you borrow some phrasing or a paragraph from a case. But there's a point, and I was going to basically say you just can't, excuse me, but you can't be an ass about it. And to illustrate what being an ass about it was going to be is I was going to use the case of Peter Cannon. And Cannon is where I begin the story, but he submitted a brief in a bankruptcy court in Iowa. It was 19 pages long. 17 of those pages were cut and pasted directly from an article he found online. He did not give attribution to the original authors. When the bankruptcy court found this out, the judicial swords fell very, very heavy. The court humiliated Cannon with a published opinion in which the court ordered him to go back to law school to take an ethics course, got some national attention. And so he was a great case for saying, don't be this person to my students. But somewhere buried in that bankruptcy court opinion was this statement that the court had initially become suspicious of the origins of the prose because of its unusually high quality. And that stuck with me because I started thinking to myself, well, if the plagiarized brief actually did its job, what's the court's concern, and why would the court feel the need to sanction the attorney for this? And doing a bit more research, you find a very thick norm enforced in a number of published cases where courts have formally rebuked attorneys for plagiarism in their briefs. And from there, I decided I was going to try to locate the interest that the plagiarism or the anti-plagiarism rule supports. And it ultimately led me to a conclusion that it doesn't really make sense to try to govern plagiarism in briefs.
Right. So I want to dig a little bit more into sort of what it looks like typically when courts identify and punish plagiarism in motion practice by attorneys. But I thought it might be helpful to kind of take a step back and sort of ask what we mean by plagiarism. So in other words, like how would we define plagiarism, or kind of how do you define plagiarism for the purpose of your article? What kind of framework might we have for thinking about whether and why we should object to it? And sort of what does that mean in the context of legal writing or kind of legal practice specifically? Like, what would it look like for somebody to be arguably plagiarizing in a legal filing?
Well, and this is something that comes up in the scholarship persistently, that it's actually really hard to define plagiarism, and often whether it is a sanctionable offense is really determines on the particular institution. So different institutional settings will have different definitions of plagiarism. But in the article, I just work on the broad one from the Modern Language Association, and this is just the idea that presenting another person's ideas, information expression, or their entire work as your own without giving them attribution, that is the plagiarism. And in practice, in motion practice, what the courts seem to be concerned about is this large-scale plagiarism from unrelated attorneys, um, whether it's whole paragraphs, whole sections that are lifted, copied and pasted into a brief filed with the court, and the original author is never given attribution or credit for their work. There's no citation.
Right, right. I mean, it seems to me, at least kind of anecdotally, that when plagiarism accusations come up in legal practice, as you say, it tends to be really egregiously large amounts of copying, and that small amounts of copying of particular phrases or passages from a previously existing text don't get treated as plagiarism. And certainly it seems to me that, kind of idea plagiarism just isn't a thing in legal practice, right? So why is that?
Well, so I don't know if courts would say or acknowledge that they tolerate small doses of plagiarism. The classic case would be summary judgment standards, right? In a civil case, there's 3 or 4 paragraphs that every jurisdiction has, which basically just outlines here are the summary judgment standards. Obviously, most lawyers just rely on the 3 or 4 paragraphs that the court has previously endorsed in their own drafting. It would not make any sense for the client for you to do independent research on the standards, draft your own original paragraphs. That would just be a waste of the client's money. That clearly goes unsanctioned. Other forms of plagiarism, I don't know if the lower level plagiarism, I don't know if the courts tolerate it consciously, or it goes past them undetected, in the sense it's the large scale copying that gets caught. I'm not so sure if the courts were aware of because I think they have such a misapprehension of the utilitarian goals of the anti-plagiarism rule. I'm not sure if they caught the lower level plagiarism, if they wouldn't still be bent out of shape about it. Does that make sense?
Yeah, no, for sure, for sure. It's like when they see it and you sort of rub their nose in it, then it makes them angry for one reason or another. And
Yeah, and that's and I know I was using a colloquialism, but that's what I meant by, like, you can't be an ass about it. And I really try to describe that. Like, you can't kind of be a scoundrel, but at the same time, when the courts do discover that larger scale plagiarism, the terms they use to describe the practice, it's reprehensible, wholly intolerable, completely unprofessional, that sort of communicates to all of us that there's a very thick norm against plagiarism in all realms. And one of the points of my paper is that ultimately I determined that plagiarism can be a very cost-effective means of drafting an effective brief. And the court's very strong language about plagiarism sort of stifles the efficiencies that might otherwise be obtained.
yeah, so I was wondering, like, when plagiarism is identified and punished by courts, is plagiarism typically the only problem that is present, or in your experience and research, do you see it kind of cropping up in kind of conjunction with or in concert with other kinds of potential issues, including potential professional responsibility related issues?
For sure. And the Cannon case that I emphasize, it's a little unusual in the sense that the court acknowledged that it was otherwise competent briefing, that the singular issue was the plagiarism. The other case that I highlight in the paper is the Lindsay Lohan Pitbull case, where Lindsay Lohan had a intellectual property action in New York against Pitbull for referencing her in a song. Her attorney in that case offered the court like a ragbag of plagiarism. Really, it was a terrible brief by any measure. And the court was really upset about it. The court basically sanctioned the attorney for the plagiarism, but it was really a sanction for the incompetent motion practice. The court kind of conflated the two, suggesting that it was the plagiarism that led to the incompetence, but that's not the case. It was the incompetence that led to the plagiarism.
Yeah, I mean, there is something really odd about saying, you filed a brief that is effective in doing what the brief is supposed to do, but objectionable because of how you created it. I mean, it almost like implies that courts are sort of assuming or asserting that, one measure of judgment of a brief is its literary merit or something. And that just seems odd, doesn't it?
Yeah, and this is really I really start the paper. I try to locate what is the interest that the court is trying to protect by sanctioning the plagiarism, especially in the Cannon's case, where, as you said, the plagiarism led to a helpful brief that covered the law and at least by appearances contextualized the facts as necessary. There are, in the paper, I sort of look at the three parties whose interests might be protected by the anti-plagiarism rule. And one of those is the court. They are the intended audience. And they certainly, if you look at the language the courts use in responding to plagiarism, it certainly looks like there's been some sort of personal affront to the court itself. But it's really hard to identify what those interests are. If a court, if its singular job is to take the brief, review the embedded arguments, and resolve the case in the way that's most consistent with justice in the cases that have come before, the origins of the argument or the origins of the prose in that brief is really irrelevant to their core task of resolving the case on the merits. And so, I looked at it from the detrimental reliance theory that Judge Posner has advanced to try to explain plagiarism norms as the impact on the intended party. And the idea here is, say, if you plagiarize a brief, but the audience is taking some sort of action relying on a presumption of originality, well, then plagiarism is properly discouraged or proscribed. But the judge, reviewing a brief doesn't take any action relying on a presumption of originality. You can never imagine a court saying, well, I was going to decide the case this way, but then I found out that brief wasn't, actually drafted by the filing attorney, and now I'm going to change my mind and go the other way in the case. That's preposterous. No court would ever do that. And in many of the cases where courts have sanctioned plagiarism, they've been very careful to suggest that the plagiarism has had no impact on how they've resolved the case. So they kind of acknowledge that there is no detrimental reliance, there is no necessary presumption of originality in the filing.
Yeah. So, I mean, like, maybe we could dig a little bit more into that. Like, when courts do object to what they perceive or define as being plagiarism in a brief, like, do they provide a explanation or a theory as to why they object? And sort of, to the extent we think that the primary value is the interest of the client, like, what is that objection that the court might rely on? I mean, other than just a sort of a background principle that plagiarism is bad from other contexts and therefore it ought to be bad in this context as well. I mean, I wonder if there isn't a kind of bootstrapping element to some of this, and like, to what extent are client interests impacted here?
So one of the frustrating things about getting into the cases is that the courts never take time to really explain the sanction. When you do have a formal sanction, like in the Cannon case, they fashion the remedy under Rule of Professional Conduct 8.3c, which basically just prescribes misrepresentation broadly. And so the idea here is, well, you've committed misrepresentation because you signed your name to a brief you didn't compose entirely originally. But that's really just saying, I'm sanctioning your plagiarism because, well, it's plagiarism. So the courts all seem to proceed as though this is like a malum se offense, right? It's of plagiarism is of such moral turpitude that no further justification is necessary. And they advance on this sense that there's some presumed universal moral objection to plagiarism. And as you and any other scholars that have worked or have studied plagiarism in the round acknowledge that, the first precept is that plagiarism norms are context specific. They don't come from some universal morality. They exist to serve the interest of the particular institution that the plagiarist operates. And so the courts can't just rely on this presumed morality. They have to identify this is the interest that is served by me enforcing this norm against plagiarism in brief drafting. And the problem is, once you take presumed morality off the table, it's really hard to identify the interest being served. And you brought up the client. There is an argument, and this certainly came up in the Lindsay Lohan case, that plagiarism is a sort of incompetent manner of drafting, that if you rely on plagiarism, you can't really be serving the client's interests. And I should say right now that if plagiarism actually allows you to draft a competent brief, spending less time and therefore less money, there's a lot there for a client to like. But that rests on a presumption that you can plagiarize a brief and still come up with something that is competent and serves the client's interests. Certainly in the Lindsay Lohan case, the court seemed to suggest that plagiarism would invariably lead to incompetent briefs, but that's not the case. Again, in the Cannon case, the court acknowledged that the brief was actually helpful. And we have brief banks at many large firms that, the idea is, of course, that young associates would copy from these the briefs that they find in these brief banks, because that would efficiently allow them to draft things without costing the attorneys a lot of money. The heavier and the much more reasonable presumption is that there's all sorts of competent plagiarism that's occurring, and most of it's just not being detected by the courts because it's being presented professionally in a competent brief.
Yeah. I mean, from a client interest perspective, it just seems quite strange to me, because in many contexts, I mean, the law might be consistent across a wide range of cases with different factual scenarios, right? And so sort of reinventing the law every time seems A, sort of inefficient, and B, especially if you're a junior lawyer, or imagine somebody's not a particularly good draftsperson, right? Like recreating the kind of certain elements of a brief, for example, might actually result in something lower quality and less effective, and therefore less beneficial to the client than copying something done by someone for whom that's really their primary skill set. One thing I've always asked my students, or the way I kind of framed it to my students, is like, imagine yourself as the client, and if your attorney comes to you and says, well, in theory, I could have plagiarized this entire brief and billed you for 1 hour worth of work, but because plagiarism is wrong, I instead rewrote the entire brief, and here's your bill for 20 hours. I mean, how do you feel as a client?
I don't, I think most clients, if you can produce a competent professional brief with a little bit of plagiarism or a lot of plagiarism and it saves them money, I don't know where their objection would come from. There is some strand of analysis in terms of how an anti-plagiarism rule might protect the client. And this is the sense of, it's only by sort of doing original drafting, crafting your own brief, that you really come to understand the client's case, right? This is the cognitive school of sort of composition theory, that it's through the writing that you really come to understand something. And so there's much to argue for the idea that, it's, if the client has the resources, their interest could be served by having the attorney sort of draft things originally, because, again, the attorney would obtain a greater command of the case and better represent the client's interests. But I note in the paper that that's great for the attorneys who serve really well-resourced clients. There's a lot of attorneys who serve clients who are really impecunious, and I cite the common statistic that well over half of America would have a hard time raising $1,000, and that means they'd have a hard time raising $1,000 for legal representation. Generally, they certainly don't have the money to pay for a originally crafted 12-page brief. That's going to take many hours for most attorneys, and that'll exhaust that $1,000 in no time at all. So I kind of suggest there is a access to justice element at play here, that by allowing for more, or at least tolerating more plagiarism, you may be offering some less resourced Americans a better opportunity to have briefs filed on their behalf.
Indeed. And again, I mean, it really strikes me that one of the odd things about the cases you describe in your paper is the way the courts seem to be sort of importing uncritically sort of a baseline of plagiarism norms and this kind of malum in se concept from a much more kind of literary contexts, and which A, doesn't really seem to make much sense, but B, in addition, they don't seem to import a lot of the other kind of subsidiary doctrines from the same context that they're otherwise adopting this kind of big picture principle. Like, for example, I certainly haven't seen courts, apply like or at least correct me if I'm wrong, but it doesn't seem like they apply much of a sort of safe self plagiarism norm. Like if you generated the brief initially, or someone at your firm generated the brief initially, then, well, it's fine. Go ahead, and that belongs to you in the first instance. So, but like in a literary context, that would be considered objectionable, for better or for worse. And then in addition, and I wonder if you could reflect on this a little bit, because it's something I'm particularly interested in, is sort of, what about like consent to plagiarism, right? Because there's certainly lots of contexts, as you know, where, lawyers or companies will generate texts that are intended to be copied without attribution, i.e., in a literal sense, plagiarized. I mean, that could be like a brief bank, that could be like forms, like a LegalZoom type situation or something like that. Or really, it could even be the forms that that the courts put into their own rules of civil procedure, right? I mean, those are there for people to plagiarize them, right?
It is indeed, and this is one of the contradictions among many that you immediately encounter when you wade into plagiarism doctrine. I call it in the paper the plagiarizing attorney contradiction, where if Peter Cannon had been a junior associate at a firm and he had just decided to plagiarize 17 pages of a brief that another attorney had written, or a junior attorney had written on his behalf, he'd be free to file that under his name, and the court wouldn't bat an eye. And we also have I avoid this generally in the paper, but there's also the tension with the fact that many of the court's own opinions are written by clerks, but only bear the judge's signature, right? So there's a long tradition in the law of senior attorneys effectively plagiarizing junior attorneys, and there's no doubt there's tolerance of that across the board. That is hard to reconcile with a general sense that all plagiarism is evil. I try to follow that a bit with, or try to offer some explanation for that with a copyright theory of plagiarism. And I know you've written about this, that there is a material distinction between copyright infringement and plagiarism, and really copyright is really focused on the economic impacts of controlling the copying of one's work, and it's really just a predicate offense to plagiarism. The plagiarism really turns on the failure to give attribution to the original author. But if you do rely on, one of the things that copyright offers is sort of ready-made doctrine, right? Some of these things have been worked through already, in the sense that plagiarism remains really incoherent. And so there is this idea, at least in copyright, if the junior attorney is working for the senior attorney, it's effectively a work for hire, and the senior attorney is free to do with that work as they see fit, and it's really it doesn't implicate copyright in that sense. And so that's one way of explaining it, but ultimately the copyright explanation just doesn't get you very far, because most of the things that an attorney would copy do not present copyright issues.
Mm-hmm. Yeah, I mean, it seems like, ironically, we rarely conceptualize copyright as relevant to what we do as lawyers, at least lawyers
Right.
in practice. I mean, like, if we assume that literary works produced for the purpose of litigation are copyrighted works of authorship, well, then, people engage in copyright infringement really willy-nilly, and no one really seems to think twice about it, including in copyright infringement litigation, right?
Right.
I mean, it's a non-trivial amount of litigation documents like alleging infringement
Yes.
by
Yeah.
clients that, looked at through the lens of copyright would themselves be infringing.
Yeah. The the copyright issues are really fascinating, and I argue in the paper, one, it's well established that a court could never object based on copyright grounds to someone copying an opinion, because all opinions are in the public domain, as well they should be. Um, the issue of whether an attorney could ever have a copyright interest in a brief file with the court, I argue that there's sort of I argue as a matter of public policy, if an attorney is taking advantage of the public courts, a fair exchange is that any brief that they file there becomes sort of part of the public repository of the law that anyone can copy for any reason. There's also just the fair use doctrine. I argue it's broad enough to include sort of the democratic values of the access to justice, this idea that we want to make sure everyone's briefs available to everyone, because the arguments or the pros embedded in those briefs may help another person obtain justice. And ultimately, that's the reason for the entire system, and that's the goal, and we should all participate in that. Nobody should try to hoard their arguments, right? It undermines the common law system in a sense, the idea that if we can sort of take these arguments and you have to pay me to use them on behalf of your own client.
Well, okay, so I was wondering, like, what happens if we think about plagiarism norms as a form of authorial quasi-property right, as it were, right? If we think of attribution as a kind of a form of literary property that has value to the author and that they want to be able to enforce in order to ensure that they sort of get their just non-economic due in attribution, is that something we should take seriously in this context? I mean, like, for example, the Cannon fellow you mentioned, as I understand, he was like, he was quote unquote plagiarizing a treatise. Well, that's a much more clearly, or much more clearly sort of within the scope of what we would conceptualize as kind of appropriately protected by copyright and appropriately a form of literary work as opposed to necessarily a form of litigation work. So should the author of the treatise have the right and ability to object to that kind of copying in a litigation context? And even more so, like, assuming that the author of the treatise doesn't object, is it legitimate for someone to object on their behalf?
So this is where I struggle the most with my ultimate conclusion that the court should just get out. The courts and professional tribunals should just get out of the business of trying to enforce plagiarism norms in filed briefs. I'm a bit of a faint-hearted apologist for plagiarizers in this sense, and what you're getting at is this moral theory of copyright, which isn't really recognized under American law, but there is some sense of the authorial expression. I describe it in the paper, and again, it's all quite squishy for me, but certainly when I have spent time on a brief, whether it's an appellate brief or a motion for summary judgment or even a mediation statement or something, you spend a lot of time crafting it. You begin to feel like you've sort of it's an expression of yourself into the world. You've spun a little bit of yourself into the sentences and paragraphs. And then certainly for me to see that taken by some other attorney and filed without giving me attribution, without giving me the professional credit that might, or the esteem that might flow from that, for them to sort of steal that from me. Yeah, I struggle with that. But as I thought about it in a deeper sense, the trouble with that approach, especially in legal practice, is that almost everything we do is sort of collaborative these days, and it's really hard to untangle whose self is being offended by the plagiarizer. So if you imagine a court opinion that's plagiarized, well, that court opinion probably was written by two clerks working closely with a judge, maybe three. There's there's more than one author behind that, and so you have to start thinking, well, whose self is being offended here? Whose moral interest are we trying to protect? So legal writing has become so collaborative and social, it's really hard to identify those interests. And in the paper, I make this point where plagiarism norm sort of arose out of the Romantic period of the 1700s, when there was this real sense of the author sort of going in a room by themselves and sort of creating this universe. That's not how things work. You can think of it in terms of the difference between the Gutenberg press and Dropbox, right? We've moved the way we produce the written word has changed dramatically, and it's become more social and collaborative. And so this sense of you're spinning yourself onto your own self onto into a paragraph or the paper, it starts to lose purchase. And the other side of it is that the common law system and the stare decisis framework that still dominates much of the legal analysis, it's intended to be derivative, right? It's your analysis is only persuasive if it's anchored in the texts that have become before, the texts that have announced rules and conducted analysis. And so the idea that you're really coming up with anything truly original in the law, especially if you're working within stare decisis, if it's an effective brief, a persuasive brief, it should be anchored in other people's writing. So everything is sort of borrowed and plagiarized. And so, at least as sympathetic as I am to the broader authorial sense of a dignitary offense when someone takes your work, I ultimately find it's just not persuasive enough in the legal practice context to outweigh the social benefits of in more efficient, less expensive briefs, especially for folks who have less money in America today.
Yeah, yeah. Well, and one of the things that I found fascinating about the Cannon case, which, as you say, is kind of an outlier because of the factual circumstances, is that it really suggested to me a way in which the sort of perceived plagiarism and related norms of the court and expectations on the attorney, in some ways, like almost seem like they sort of induced the plagiarism themselves, in the sense that, like, in the context of that particular case, right, the objection is that the lawyer copied from a treatise and didn't acknowledge that the source of the material was from the treatise. And I can't help but ask, like, why is it that the author, that the lawyer made that decision? Because I mean, it seems like, at least in the abstract, to my mind, like, if you were to acknowledge that all this text came from the treatise, this is black letter law, my client wins, that actually just makes your argument stronger, right? I mean, like, leaving out the attribution is not a plus, it's like a minus, right? The lawyer is less of an authority than the objective, neutral, like, kind of like high status, arguably, treatise writer, right? I mean, it almost feels like, because the court is creating this expectation of originality and labor, they're actually kind of inducing the very lack of attribution that they then turn around and punish.
That's right, because there's a sense if I don't know if Mr. Cannon had block quoted the entire 17 pages that he cut and paste and gave it a proper citation, if the court would have been any more pleased, right? That would have just brought to the attention the cutting and pasting, which the court seems to so deeply object to. But I I do think there's room for compromise here if there really is a concern. I certainly don't think compelling attorneys to block quote the 2 or 3 pages that they may cut and paste from a different source is effective. I mean, there's plenty of well-respected judges who have written, "Please don't no block quotes, more than a paragraph long." So I think that's probably not the solution, but dropping a footnote saying that the following 3 pages have been effectively cut and pasted from this source, I have found that is effective, and it doesn't make sense for my client for me to spend extra time doing this. I'm not sure what the harm there would be. There is a class of plagiarism or cutting and pasting. So especially with the proliferation of unpublished decisions, it may be that would be the great source for this cutting and pasting, right? There's an analysis in an unpublished opinion that you want to cut and paste. You run into the rules against citing those unpublished cases when you cut and paste from those. So you cut and paste from them, if you're going to follow this rule that you have to at least drop a footnote, technically then you're in violation of the rule against citing the unpublished decision. So there's all these tensions that would have to be resolved on some sort of compromise position there. Does that make sense?
Yeah. No, that makes a lot of sense. That makes a lot of sense. So, Andrew, in closing, I wonder if we could like take
Sure.
a little shift for a second, right? Because, in addition to being a legal scholar, you're also a professor and you teach legal writing, meaning you're teaching right around the subject area that you're doing scholarly work in. How do you square this take on plagiarism in the legal profession and what our expectations on attorneys ought to be with what you teach your students in class, right? Because this is pretty clearly a violation of university plagiarism norms, for better or for worse. I mean, does this, to your mind, suggest that we should like kind of have sort of like a do what I say, not what I do type sort of approach to teaching legal writing? Like, don't do this until you're out in practice? Or does it suggest that maybe we should rethink the norms that we articulate as governing student work as well?
I'm really happy you brought this up because it's a really important distinction, and one that I do make sure that my students understand, especially the ones that wander into this article. In the academic setting, when I am asking them to draft litigation briefs in my writing courses, I am trying to harness the cognitive impacts of the sort of composition theory. I want them to struggle by themselves with drafting the paragraphs, constructing the analysis. That's part of the learning process. And I do grade them on a presumption of originality, meaning, as like most law schools, I have to grade on a curve. And so if I give them a grade presuming something's original and it's not, it messes up the curve, and it's a fraud that's committed on their classmates. They're obtaining a grade that they did not deserve. And so I do make sure that it's very clear to them that what we're doing in this classroom is really a learning experience. Yes, I'm teaching them the conventions of legal communication and the sort of conventions of standard legal practice, but I'm also teaching them legal analysis, and I'm doing that by harnessing composition theory. When they get in practice, that's going to be something different. They're going to find some efficiencies, and who knows, in 10, 20 years, plagiarized briefs may be the norm, and or copying briefs may be the norm. But certainly in the law school classroom, it still has to be original work.
Well, Andrew, thanks so much for coming on the show. This was a lot of fun, and I'm always delighted to talk about all things plagiarism.
All right, I look forward to your follow-up essay on your plagiarism is not a crime.